All right. Good morning. I'm finally here. It's been one of those mornings. So prosecution has one more old witness. It's the first witness we heard from, I believe, Detective Casey. So they're going to rest after. Well, they're going to do a motion, I think, to start. They'll rest, and then we'll see how much of a train wreck Brooks's opening is. With that, let's jump straight into it. I'm gonna get started at 1.5 speed. Good morning, Empty Woods. I'm gonna get started at 1.5 speed because I want to get to his opening in real time. So let's get started. And good morning, Static, too.
Can you just make 2 copies of that?
Gotta open the Bible.
Yes, and then 1 to each. You give 1 to each party. Thank you. No, you can. You can. Sam, go ahead. I was going to call the case.
Okay.
Do you need something to talk to him for a second?
Yes.
Go ahead. You can turn the audio off for a second.
Oh, I assume that's planning, scheduling his witnesses, which, once again, the prosecution's not required to do.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good morning, Judge. Leslie Basie and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
Just 1 second. Make sure
He's got to get his script to give his name.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and do not consent to being called that name for the record.
All right, thank you. That is noted. The record will also reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
And don't consent to being called that name.
I understand, sir. All right, I do want to
That
put on the
suit's
record I
gotta be
gave the
stinky
parties
by
this
now.
morning. It's an excerpt from a judicial bench book on opening statements. It's about 1.5 pages. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope, and other things.
This is
And as I
necessary.
indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference
I
subject
think
matter
so too,
jurisdiction, because
Static.
despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments. With that, I
For the
believe
record, is this the which you're referring to is
the 1.5 pages is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is
It
what guides
doesn't
me
follow the
as
rules
I
anyway.
preside over cases.
okay? I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement. I'm pretty aware that wouldn't be part of an opening or closing statement. I don't
Okay, great.
I don't get why
I
that's
wanted to make the
relevant.
record clear.
Because
I
your
appreciate you indicating to
performance
me that
so
You're
far,
aware of that.
Even though subject matter jurisdiction has not been proven on the record and should
Sir,
be
it does
addressed.
not need to be proven on the
It-
record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by constitution and by statute.
And who was the complaint filed by? Because subject matter
Sir,
jurisdiction has
I'm
yet to
not
be
going to go
proven on
down
the
this
record.
path today. I'm just advising you, you cannot reference that in your opening
I mean,
statement.
That was something I've already had the common sense to know, but also
you
subject matter
don't have
jurisdiction has
any
not been
common
proven for the record.
sense.
All right.
She
next
has to
topic. Then,
assume
the state has
that
filed
you're
a
going to
motion.
not follow the
By the
rules.
prosecution.
The objection is noted. It is not legally sound. It's overruled.
It's definitely legally sound.
All right,
Yes, you have to
Attorney,
prove
I'm going to turn to Attorney Hopper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh, but.
It was served on Mr. Brooks last night in the jail, Your Honor.
All right, go ahead. You can make.
I didn't look at the document. I set the value, return for
If
value.
you read it
document. I didn't look at it.
online, it's got to be true.
So I don't know what I'm supposed to say to that.
All right, well, Attorney Hopper, it's your motion. I'll hear from you.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads as it reads right now. It reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial. We're not asking to change any criminal charges. We're not asking to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
All right, thank you. Any position on that, sir?
Yes.
He objects.
First of all, for the record, there were originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think one change of one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word. It's
Needs to
kind
be
of, at this
heard
point, kind of a moot
because they
point.
can't just
It's been
change
charged
it
like this for a
unilaterally.
year, basically. But the language hasn't ever been referenced to being changed before yesterday. So what is the significance of this now at this point?
Thank you, sir. Court is guided by section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial, the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there's no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd, 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd, 1, and State versus Gerard, 189 Wisconsin 2nd, 505. The first of those 2 cases is a Court of Appeals case from 1999. And then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178
The
Wisconsin.
judge is not on
729, a Court of Appeals
speed.
case from 1993.
I'm just playing it at 1.5
As far
speed to
as
catch
whether
up.
this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read; those are based off of the information.
And when
this
I click
proposed
on
amendment
comments,
does
I don't know
conform
if they're
to the
showing
proof.
up properly
There is
for
no
you guys.
prejudice to Mr. Brooks. It does not change
StreamYard
the charge
doesn't
in
seem
any
to be
way.
working
It is still the same
on my
offense.
end for it.
It's still from the same
Just shows up
general
sort of as
information
a
that
shadow.
was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question about that. So the same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to
Good
give
to
an
know.
advisory opinion, which I will not do.
But what happens if that happens?
I'm not going to answer that, sir. Can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually.
It's unconstitutional to
Okay,
give
so we go
advisory
back down.
decisions.
The state has not rested yet. Will the state anticipate calling any other witnesses?
Yes, Your Honor, as indicated yesterday, we do intend to recall Detective Casey to the stand, and I'd like to make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the
Exactly.
state's
Sovereign
early in the
citizens
presentation of the
object
matter. His
to
focus
practicing
at
law
that
from
point
the bench.
was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury on the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes. He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main. And essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case. There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Main with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we have been very efficient in our presentation.
I think
believe Your Honor
law
would agree
for
with that.
dummies
We're not wasting time here, but
is above his
just
level.
have a few more questions to wrap this up.
Right. Any position from you, sir?
He needs
Yes, I do.
law
And
for
I'm sorry,
abject
what was just said,
morons.
The prosecution feels that they've been efficient in their presentation. So it seems like to me an attempt to get more questions in that could have been asked in the first place.
No,
If Your
because
Honor recalls,
in the interest of
Detective Casey was,
efficiency, they waited to
testifying for
introduce
quite some time,
new
to the point
evidence
that we actually had to have a break
so that he
before I
could
can
wrap it up.
cross-examine Detective Casey, if you recall.
The
He was up there
prosecution
quite some time.
gets to decide
That was
the
more than
order
enough time
in which they
for
present their case.
any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused.
No.
So essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be answered. And essentially what more could be gained by a second testimony from Detective Casey? What more can be
You'll
gained
see.
that hasn't already been learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to
Luckily, they don't need your permission
even the
on how to present their case.
even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go. As seeing as how he was up there for quite some time.
They could have
None of those
been.
issues were raised at that time.
But they could have been
What would be the
too
significance
confusing
at this point?
at that point.
When essentially I should be already presenting my defense at this point.
You
in
should
the
be,
trial.
except you've
I don't
wasted
see the
so
relevancy
much
of it,
time.
and to my knowledge, he was excused from his subpoena. So
He hasn't been because
Thank you,
what's the
sir.
relevancy?
Thank you, sir.
you argued
The court
against
has
him being
discretion Under
released.
90611, it's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle of the driver throughout the investigation, identification of certain victims. In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary issues then from the state?
Your Honor, just, I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted by the court is what she has, so that we can clear that up before we actually rest.
All right, thank you.
That's
Anything from the
true.
mayor's view,
Yeah,
sir?
just a quick question about
The prosecution would have to
I will be able to
release him,
Oh, yes, sir.
but he's
Is essentially anything left
on
off limits
Brooks's
to my
witness list as
or-
well. So he wasn't released, period.
I may limit, depending on where we go, if the questions deal with what he testified to previously. It's primarily to cross-examine based on the new testimony. However, 90611 also says this: the witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
Because I'm not intending to go too much back into the previous.
I mean, that
testimony,
is
but I think you made
assuming
a few
Brooks
points from
actually
earlier
follows
testimony
through
that you took
following
away. I
him.
just wanted to make sure
I think that's fair.
that wouldn't be a problem.
I think that's fair, sir.
Also, really quick,
Exactly.
I did. look
They've
over
been trying to
some,
tell a narrative,
information provided by
and
prosecution as far
the
as,
narrative required him
the
to
pretrial
come
offer
back.
that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I'll put together, or started to, I won't say it's completed, that would be fair to say. I'll put together, or started to put together a counter offer. So I just wanted
A
to advise the court that
counter
I
offer.
was putting that together.
All right, thank you, sir.
This isn't
If and
contract
when you do,
law.
Provide that to the state, please let me know so we can make a record of that. All right, anything else? Not, then we'll have the jury brought out.
We do have one last large map here, Your Honor, I'm going to ask to put up and face backwards like we did the other day.
All right, go ahead, since the jury.
Morning, Darlene.
Yeah.
They have been amusing all trial. The German's mouth is full of bratwurst.
All rise.
Time to start arguing subject matter jurisdiction. Come on, Brooks. Jury's walking in. It's time for you to argue. I think he'll get
Thank you,
more
everyone. Please be seated.
knockwurst
Good morning,
than
ladies and gentlemen of the
bratwurst.
jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here. If at any time that temperature is too cold for you, let me know and we can have that adjusted. All right, Attorney Opper, you may call your next witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
Good morning, Detective Casey. Please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and Teresa will swear you in.
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat. Please state your first and last names for the record.
Thomas Casey.
Thank you. Go ahead, Attorney Opper.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you.
The map we've seen over and over.
And we've had testimony about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, state's exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection leading.
Overruled. Foundational. The witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection leading.
Overruled. You may answer.
It's his
So
new
initially,
favorite,
that night, we knew that
leading.
the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
They
And then
argued
eventually were there follow-up
jurisdiction
interviews conducted
more
with these individuals?
generally.
Yes, there were.
What if the individual
I
was a
think.
person under the age of 18?
Objection leading.
Overruled, you may answer.
If the person was a minor under 18, then we would reach out to the parents.
But
to the parents.
personal
Some
jurisdiction
of the kids
would
weren't able
be
to talk to us, but we
more
got the majority of their statement.
in line with what they argue.
And do you believe that the names on Exhibit 15
They just tend to usually say
truly reflect all the
jurisdiction.
injured victims that you were able to identify in the course of this investigation, sir?
Objection speculative.
No, I do not.
Hold on, there's been an objection. It's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection leading.
Overruled.
Just because of the scope of the investigation, we
getting
had so many
desperate.
people that were hurt. We had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately, I learned later on there's even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged.
That's hilarious.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection leading.
Overruled, foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So was, in your mind, when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection leading.
Sustained is to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We
Objection
exclude those.
speculative.
Overruled, though, detective.
He knows. He
Those
made
people
the
were
map.
There were some people like that, right?
Yes, they
Objection
were.
leading.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right. I'd like to put up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
I'm sorry, you said 32? You said 32? Okay, thank you. Sorry, I just missed it. Just to the witness or published, because it's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
But
Permission granted.
Okay, thank you. And while we're waiting for it to come up in the jury
Objection.
box.
It's already been
I don't have no
received.
mistake.
It may take a second. Hold on. If it's not, let's check the cables.
We don't have it either.
I can see it. The witness can see it.
Mhm.
Thank you for letting us know, sir.
Just the front tables, back tables on, Your Honor.
Hold on. Stop source first. I know. Anything? Yeah. You can see it on the screen though, right, sir? There's a screen, obviously, on the far side of the courtroom and then to your right.
It's always better on here. 'Cause
I understand. We'll get our tech guy over here to look at it, but it's previously been received and we can see it on the two other monitors. So for now, we're going to continue. If there's anything new, I'll make sure to pause. Go ahead.
Detective Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
Overruled, it's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
Objection speculative.
Overruled, he may answer.
Yes, I do.
And do you know the names of these people?
Objection. You're saying.
Overruled, he may answer.
Yes, I do.
What were their names, please?
Kathleen Ballmeyer.
Speculation.
Overruled,
It's
he
not.
may answer.
You don't have to
Kathleen
object to
Ballmeyer,
every
Jennifer
question.
Stover and Mitchell Lampkin.
What was their role with the dance team?
Go ahead.
Jennifer and Kathleen were support people.
The detective was
Jennifer was
challenging
marching in the
him
parade,
there,
And then Mitchell
staring
was there
him
to hand out
down.
candy with a stepmom.
I'm going to now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom. So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then I
Yes,
will
okay.
pause to get the tech people in.
All right. And
Go ahead.
Objection
Bailiff.
to relevancy.
Overruled.
It's already been received.
Bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
She just said.
Looks like it's a minute 23 according to what I can see on my monitor.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection speculative.
Overruled.
He
may
only
answer.
has a list of 4
Could you identify them
objections.
by using the touchscreen?
Objection leading.
Overruled. He may answer.
I'm gonna draw one big circle.
Okay,
It has 2 individuals. It has Jennifer and Kathleen. Kathleen has the red
Morning,
jacket on,
Cy.
and directly to her left would be Jennifer.
It
in the
is-
black jacket.
One and a
Hard to see
half
right now, but
speed.
as they-
It's very hard to see.
as they
Keep going.
walk, could you see 2 people walking there, sir?
Yes, ma'am.
Please clear the screen
I want to get
and continue
the
playing
his opening in real time, and I got a bit of a late start.
and pause. And I'm sorry, because I can't see the counter yard.
It is at 44 seconds.
44 seconds. Thank you. Pause at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection speculation.
Overruled. He may answer.
Yes, I do.
And who is that?
Leading. Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Do you know Mitchell's approximate age?
Objection speculative.
Overruled.
I believe he's about 10.
All right, we can take down 32. Did this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection leading.
It's foundational. here.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell
Sustained.
and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
have our IT experts. Hopefully I can get this figured out.
A lot of pressure.
Go ahead.
Could you put something on the screen that's okay with you for a moment?
Next one will be 132 if you want. No, I'm sorry, 55.
It's on our screen.
It's on now.
He'll stall
Hold on, let's make sure. Do you have it
and
now, sir?
object
Yes.
and
Oh, good. Great. It's on mine.
whine
It's on
and
the witness.
cry
All
till
right.
the end of
Just like
time.
real life. You call the help desk and they show up and oh, now it works.
Jury monitors, we're working. It's not, hold on, let's make sure. It was just working.
Ooh, that's brutal. That's brutal. I think a newspaper
It can take
has a head of lettuce. Will this lettuce outlast Liz Truss?
What do you say this one?
And I think the
This is
lettuce is
55.
still there.
All right, it's not. Very good. We're up and working. And 55 has previously been received, so go ahead.
Objection to the relevancy of 55.
Noted. Overruled. Go ahead. Attorney Alford.
Detective Casey, exhibit 55. Can you see at the end of the road there or the top of the screen what units is involved in exhibit 55, please?
Yes,
Please tell us.
Objection leading.
Overruled.
it is the dancing grannies that are approaching from the right.
And
Did she?
one of the dancers we have heard
I'm not
testimony that was about
surprised.
grannies was a woman by the name of Lola Hospital. Is that correct?
Objection leading.
Overruled.
hey.
It's foundational. The witness may answer.
Brought
Yes,
in
she was.
Lola. I told you.
Is there video showing Miss Hospital being struck by
I
the
told
SUV?
you.
Objection leading.
Sustained is to the form of the question. Please rephrase.
Sure. Is exhibit, you've seen exhibit 55 before?
Yes, I have.
Are you able to identify Miss Hospital? I'm sorry, yes, Lola Hospital in exhibit 55, sir.
Objection leading.
Overruled.
I
Yes, I
told
am.
you he
I'm gonna
would
play the
be.
clip, Your Honor, from
Bringing up
from
Lola.
4 seconds to 8 seconds at 50% speed, and it is zoomed in the middle of the road where the
I knew it.
dancing grannies are located.
All right, go ahead. Thank you.
Because remember, the dancing granny that testified misspoke and said
Please
Lola
describe to the
was
jury what you just saw in
not
the video, sir.
injured.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospital and then striking 2 other dancing grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Miss Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask
Well,
that Exhibit 118 be
There's
published for the jury.
evidence that
This is previously
that
been
charge
admitted.
can't be dismissed.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the
It'll at
item
least go to the jury.
shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Affirmative. The first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark.
Disparaging.
Your objection is noted, and the answer will stand.
The mass murder.
I will instruct the witness to simply describe what he is seeing without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you. When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection, lady.
Overruled. The witness may answer.
Yes, I did.
What did you determine?
I determined that they were the jacket, hood, and hat that Virginia Sorensen was wearing while she was walking in the parade.
She was carrying the banner
Like
for the
to
dancing
display to the
grannies
witness only, please. Exhibit 177.
and killed.
This has not yet been received, Your Honor.
All right, go ahead, please.
Is 177 on your screen, sir?
Yes, it is.
And what do you see in Exhibit 177?
Objection, lady.
Overruled.
I see two dancing grannies carrying a Milwaukee dancing granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Is that 177?
177, yes.
Yep. And if the jurors will let me know when it's in the jury box as well, please. All right, thank you. It's there. He's got that look down.
Okay, just so we're clear on the record, please circle Virginia Sorensen in the hat.
Hey, look at that hat.
Objection, lady.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Detective Casey, there were many videos that have been shown to this jury, correct?
Objection, lady.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there has been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection, lady.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Daring him.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay.
It is now.
All right. Do you see Exhibit 150?
Yes, I do.
Please describe what you see in Exhibit 150.
Objection, lady.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to investigation?
You've brought up the
overruled.
license plate over and
Exhibit
over.
150 is received. Permission to publish is granted.
The image is a little blurry, correct?
A tad.
Can you please point out the license plates in the photo and read it for the jury?
It's okay if I circle it?
Overruled. You may do so.
It is pretty blurry.
That is the license plate number, and I read ADP 9256.
All right. Now I'd like to show to the witness only number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I
Bet he
do.
does.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received. Permission to publish granted. The objections noted and overruled.
I recall this station had 140 exhibits. How do we get this many?
Keep going, Attorney Amber.
Detective, please describe what you see in 151. I think you did describe it. Strike that. Please circle the license plate and read it for the jury.
Objection, lady.
Overruled.
ADP 9256.
Hey, it's the rear license
It's the
plate
map.
this
Okay, I'm sorry.
time.
Gotta wait for the jury.
Go ahead.
Detective Casey, during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with the same license plate?
Objection, I don't consent to be called their name and misleading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection, leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
Please identify 175.
This is
Objection. Relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays the vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection, leading.
Overruled. The witness may answer.
Leading
We
would
obtained it
be,
through social media.
Okay.
did you
I
get
mean,
this
it-
photo
this is
from
a photo
social
versus the
media?
This is the photo taken from
Hold
the
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled
a,
or sustain?
Overruled.
You said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry, I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that. For any confusion I may have
It's
caused.
almost like judges'
this is a screenshot taken
Misspeak.
from a video.
trials
I'll
are
move to
in
admit
real
175 and
time.
permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
Where's, oh, sorry.
The jury would also let me know when it's in the jury box monitors or on the jury box monitors.
Hey, it's
All
the
right, go ahead.
Detective Casey, is,
totaled vehicle
person you know is Darrell Brooks
with
in
the
this
license
photograph?
plate.
Objection, I don't consent to being called their name and misleading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion.
All right. No, this is
How do you know that's
From
Darrell Brooks
earlier.
there? His back is to us.
Objection, leading.
Overruled.
I've watched the video in its entirety, and I've seen his face in the video.
Okay, that can go down, please. Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection, speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each. So I would say probably 300 to 400 videos we've collected.
that's a lot
What
of
were the
evidence.
source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection, leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection, speculative.
It's not
Overruled.
speculative. He did know
Yes, I
what
have.
he watched.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection, leading.
Overruled. The witness may answer.
I've never seen anyone driving the vehicle besides the defendant in any of the videos that I looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection, speculative.
Overruled. The witness may answer.
None of the videos that we had looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop, a complete stop along the parade route?
Objection, leading is
Oh.
speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection, leading.
Overruled. The witness may answer.
That goes to the
I
hit
never
and
observed
run.
in the videos
resulting
the
in
driver of
death
the vehicle to stop,
charges.
check, or exit the vehicle on anyone.
He had a duty to stop and render aid.
There was testimony earlier in this case about witnesses observing multiple people running from the car. Do you remember that?
Objection, leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correction, leading.
Overruled. His answer may stand.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection speculative. Just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Just tell the jury what happened when the SUV was found on Maple.
Objection leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection leading.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed people that reported people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
Stare him down.
My understanding that that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection. I don't consent to being called that name for the record.
Noted. Overruled.
How did you get it?
Objection leading.
Overruled. The witness may answer.
He just stated how he got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department Secure Storage Facility. Mr. Johnson was over there processing the vehicle. I went there.
We heard from
He was with
Johnson
me, and I
yesterday.
checked the vehicle to see if the key would work in the car.
What did you find?
Objection leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you. Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection. I don't consent to being called that name. He's leading the witness.
Overruled. Foundational. The witness may answer.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection. I don't consent to being called that name. Leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept at the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that that is his name that he has always gone by. I have also
Imagine
spoken
that.
to his mother, which states that that's the name that he has gone by always.
So his
I'd like to put on the
objection
screen
is
for
a
the
recent thing.
witness only exhibit 88.
Go ahead.
You see exhibit 88, sir?
Yes, I do.
Objection to this was the relevancy.
Overruled. Go ahead.
Grounds are overruled.
Relevant.
In what way is it relevant?
She doesn't have to explain that to
To the
you.
counsel alleged in this case. Go ahead.
Can you please identify exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Brooks.
Time to prove up the bail jumping charges.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form? Please leave it to
Morning,
the bottom.
Susie. We're on 1.5 speed to
The
catch
end
up.
bottom
Objection
is
leading.
Overruled. The witness may answer.
2/21 of 2021.
Was Mr. We'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
No,
Overruled.
they
The
can't
witness may answer.
discuss what the
All the
charges
that I see are
were
felonies.
To your knowledge, was this bail in full
because
force
that
and
would
effect
be
on November
bringing
21
in
of
prior
2021?
bad acts.
Objection.
But
Overruled.
it being
Can
a
answer.
felony
Yes, it was.
charge
And in the middle of
goes
the
to
form,
an
do
element
you see the
of
conditions of bail
this
that
bail
were set upon
jumping
Mr. Brooks?
charge.
Objection leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the third bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection leading.
Overruled. The witness may
The
answer.
problem is we're going at 1.5
Committing
speed
crime.
to catch up
Thank
so
you.
that
Move to admit
we
number 88, Your Honor.
see his opening
Exhibit
in
88 is
real
received.
time in
Like to
real
display for the-
speed. That's going to be real stupid.
Overruled and permission to publish.
I'm sorry, I did not seek to publish this, Your
Oh,
Honor.
all right, turn that off.
Request legal finding of fact that
The objection is noted. It's overruled. Continue. Attorney Hopper.
Thank you. I'd like to display for the witness only Exhibit 89.
He's getting mad.
Go ahead.
Sir, can you please identify 89?
objection.
Overruled.
Relevancy.
Overruled.
This is a,
This has been stipulated to as well. How's it
No.
happening? How's it being admitted?
The objection's noted. It's overruled. The witness may answer.
I request legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
this is a bail bond from Milwaukee County Circuit Court for Darrell Edward Brooks with the date of birth of 2/21 of
It's an
1982.
essential element
Is this a
of
different
the
case than
charge.
what was displayed in Exhibit
It's
88?
relevant.
Objection legal.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection legal.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Once
And on the
again,
bottom of the form, can you tell the date that this bail was issued?
level of charge,
Objection legal.
not
Overruled.
what are the charges.
It's 11/11 of 2021.
The directing your attention again to that same location in the middle of the page under paragraph B, the third bullet. Would you please read the conditions of release that were set by the
course.
court in that case?
Brooks
Overruled. The witness may answer.
could
Defendant shall
open the
not commit
door
any
here
crime.
on
To
cross.
your knowledge, sir, was this bail in full force and effect on November 21 of 21?
Objection speculative and legal.
Overruled.
He's got to be real careful.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or 2 items. 1 second, please. I'd like to display for the witness only Exhibit 13.
Objection. What's the relevancy of this? How does it say any foundation to testimony?
I'll give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if Exhibit 13 is a video, sir?
Yes, it is.
Have you seen this video before, sir?
Objection legal.
Overruled.
Still relevancy.
Um,
Where's relevancy?
They're
The state is
establishing
asking
the
foundational questions.
the
The objection's
relevancy.
a bit premature. I'll take it under advisement. Go ahead, Attorney Hopper.
Yes, I have.
What does this video depict?
Objection legal.
Overruled. The witness may answer.
Objection speculative.
Overruled. Go ahead.
He's getting desperate.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. It also, that's the address of Dawn Woods, the mother of Darrell Brooks. And on the lower left-hand corner, you can see a Ford Escape.
In the
Hey,
lower right.
wow.
I move to strike that. How does he know?
The objection's noted. Overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
In the bottom right-hand corner of the exhibit, do you see a date and time stamp for this video, sir?
Objection legal.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
Hey,
What, is,
wow.
what do those numbers represent, sir?
Objection legal.
Overruled.
To me, it means that the video was taken on November 21st, 2021 at 1:26 p.m.
There's a good chance.
And do you believe this video is
I
a true and
think
accurate
he's
representation of the events of that afternoon at that location?
Aware
Objection speculative.
that the door's there.
Sustained. If you
But
could be a
his-
little more foundation.
Sure.
please.
Inartful
How did you come into
method of
possession of this video,
questioning
sir?
could open it.
The defendant's mother provided it to us.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection legal.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
So this
Move to admit
shows
13, Your Honor, and
he
permission to
took
publish.
the vehicle
Where's relevancy?
from his mother's house.
Noted. Overruled.
3
Exhibit 13
hours
is
before
received.
the
Permission to
attack.
publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed. Oh, hang on, don't play it.
Yes, the jurors will let me know when the monitors are displaying the video. All right, go ahead.
There's the escape in the bottom left. We just see the hood. Hey, there's Brooks in a red t-shirt walking to it. It's a Ring doorbell cam. Well, security cam. There goes the red. Ford almost escaped.
Detective Casey, were you able to see any emblem on the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection, leading.
Overruled.
I did not.
I'm gonna put up State's Exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is
Love
a still
this
shot
area.
taken from the video.
The same video we just saw, number 13.
Yes.
Move to admit 14 and permission to publish, Your Honor.
Objection, vote is leading.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
The Ford
Being called that name.
dangerous weapon.
Noted. Overruled.
Yes, I do.
Can you identify or, excuse me, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet. I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip-flops on with white socks.
That's what he was arrested in.
What's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And that's what time?
Objection, leading.
In on the 12-hour clock.
Objection, leading.
Overruled.
That'd be 1:26 p.m.
All right, thank you. Any other questions, sir?
We cross.
In the two exhibits we just watched, 13 and 14. You see anyone driving the vehicle?
No, I do not.
Do you know if anyone was in the vehicle at the time that you see it pull away?
I would assume based on my training experience that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in the vehicle?
He asked and answered.
That was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections. Not sure what the objection was, but the answer may stand. You can ask your next question.
Let's go back to exhibit 175 and pull that up for the witness.
Would the state please pull that up? Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well.
Is this the... Oh, no. Was wondering if it was the bail form. I've heard he was an
You just-
aspiring
you
YouTube
just testified
rapper. I
That
wonder
was
if
the
this
alleged
is
defendant. How do you know that?
one
You
of
see
his
the face?
rap videos.
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that's circled.
So how do you know who it is?
He said he saw the whole video.
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Can you clarify the only one that is shown today, or the only one that has ever been
The
taken?
only one that's,
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking the question.
From just looking at this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment.
he knows
Strictly that.
through
Could you ask
his
your question, please?
I'm gonna
previous
ask the answer.
knowledge.
Sustained is to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now, that you cannot tell who the circle individual is? That'd
He
be fair to say.
can. He knows.
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
Early, some of them as late as yesterday.
The same night of the incident or in the days following?
I did not see it the night, but it would be the days following that I've seen it.
And at that time,
Yes, by
that
then
vehicle
he
belong
knew
to?
it was you.
Yes, I did.
And did you have knowledge of the usage of that video? I mean, the usage of that vehicle?
Yeah.
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained is to the form of the question. If you limit, perhaps direct him to a specific time frame regarding the use of the vehicle.
Are you
At the
aware
time
of
of the
who was
incident?
using the vehicle
Yes.
at the time I
And what-
drove it through the
correct.
parade?
And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
I'm gonna go another route on this.
You done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to
You
seeing
should have done
The
that
entire
on the
video
day of
is
the
still framed.
parade.
exhibit
Gone
came
another
from,
route.
correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety what we recovered from your social media account. I'm not sure if there is a longer version someplace, but
Did you see the video in its entirety?
He
The video
saw
that this
what was
exhibit
on
came from.
your social media account.
yes,
And are these the only two individuals that you observed in that video?
they are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Can you clear that circle?
Thank you, Madam Clerk.
Would it be fair to say that from looking strictly at the
I
exhibit
think
that we're
we'll
viewing right
be
now,
caught up in about
that
5 or 6 minutes,
both individuals have the same?
10 at the
Hairstyle?
most.
It would be fair to say.
Can we clear the X's and clear the exhibit?
Thank you.
We go back to exhibit 13. Publish.
Go ahead. The state would assist, please.
13. Can you play it? Well, just play it out. I'll tell you when to pause it. That's okay.
Go ahead.
It's not up yet.
Oh, thank you. We're gonna wait until it's in the jury box.
Okay.
This is the ring cam from his mom's house.
Okay, go ahead. Thank you. As a reminder, 49 seconds long.
I don't think I'm gonna need the. Well, I don't know. It might-
Hey,
Pause.
there he is.
Right there, the individual that you observe. Right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
No, I don't see a video or a hoodie anywhere in the video.
You were
Can you take the X
arrested
down?
in the red shirt, though.
From this angle, it'd be fair to say that you can see the very front end of the vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You see half the
I
hood.
cannot see inside the vehicle at this time.
So it'd be fair to say that just by looking at what we're looking at now, you would know if anyone's already inside the vehicle.
This has been answered, Your Honor.
I'll allow it. The witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That's correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it'd be fair to say that you're not sure.
It's fair to say
This
that
is
I'm not sure.
also
Can we
3
pull this
hours
down?
before.
Wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Same
Go ahead.
exhibit 13.
It is a difficult concept
would-
if you're a
Put
moron.
that back
Right.
on display.
It-
and There you go. Do you want any more of a
So
play or
it's
just the still?
difficult for
We wait for the jury,
Brooks.
or do they?
It's up.
No, we don't need to play.
Do you need it to go to a certain point?
Yes,
All right, do you know what point?
I'm about to right now. Looking at this house right here, do you see an address posted anywhere on this house?
In the photo that you circled, no,
So it'd be fair to say that you don't know the address of this house.
He does.
that is incorrect.
You just said that you don't see an address posted anywhere in this house.
It's not in the
So from the
video.
vehicle, I mean, strike that, not the vehicle. I'm still looking in the corner right here.
He knows the address. He
From the
went
video that we're
there.
viewing right now, do you see an address posted anywhere on this house?
Asked and answered.
I have not seen the address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this
Hold
video,
on, you have to let him finish because that was not the question you asked. You asked him how he knew. He can answer. Go ahead, Detective Casey.
I've been at this address before. I've spoken to your mother. I've been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address, the 4014 North 19th Street.
you recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
I believe that I saw the video first, and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was.
He did because he
That would be an
received
incorrect
it
statement.
from your mother.
You just said that you saw the video first before going to the house. Did you, or did you not say that? That'd be fair to say.
He also said he received the video
Because
from
I'm
your
not confusing
mom.
your question. We received the video. We know from getting from your mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for
I
me.
follow you, but that clarification wasn't stated before. So that's fair from the clarification of how you just clarified it. Can you clear it to
We're
second,
done with
please?
this exhibit.
Oh, once again, my black hole theory.
We'll take it
He's
down.
so dense, he sucked everyone into the SUV.
You made reference to a key being found. Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
And we heard from the officer who found the key in your pocket.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
That's what detectives do.
What are you speaking of?
The key being found.
That's correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
You made reference to there being a couple, was the word you used, a couple ways to identify individuals. And you stated that you had spoken with the mothers of the alleged defendant's children. That'd be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Like I said before, the
Easier
fingerprints was
to
one way.
what?
We also verified it talking to his family members that his identity.
Any reason why
They're not in this
let me
for
back up.
easy. They're in this for
Is it fair to say that
completeness.
there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
He objects to them having more information.
To be fair to say, fingerprints are pretty accurate, though, correct?
No.
Would it be fair to say?
I think that would be fair to say.
So it would also be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Would that be fair to say?
Objection, that's compound and difficult to follow.
It's
And
not-
argumentative.
Sustained is to the form of the question, sir. Please.
That was
repeat.
very clear.
Sustained is to the form of the question.
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in
Whoa,
Mountain
whoa, whoa,
Falls.
whoa, whoa, whoa. Can we strike that? Why do the names have to be stated?
Overall, he
You
was answering the question.
About them.
His answer may stand. Your request is
Specifying
denied, and the
where
witness may
he
continue
spoke
answering.
to
I spoke to
them.
Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
To speak to her.
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record, I don't recall listing anyone as a witness, just for the record.
For the record, Mr. Brooks, you can't testify at
It
this
would
moment.
have
You'll have an
been
opportunity should you
his
choose.
I
attorneys.
just wanted that clear for the record since
It
what was
can't be,
said.
it's struck from the record
At
at
the
this moment because
time,
you're
his
attempting to testify.
attorneys
The jury will
would
disregard
have
that.
had them.
To show
The
that
jury
I'm
will
not
dis-
doing that. And if
The jury will disregard those statements made by the defendant as
Subject.
that he is not testifying, and it would be improper at this time for the court to receive them.
I don't think a
Go-
record should be
next
made
question,
of
sir.
something that I didn't do.
Next question, sir.
It's ridiculous.
Stop arguing. Stop with the
So
commentary.
you said you went to Iowa to
Zap him.
try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained it for all bases. Next question.
He's getting mad.
Was that an attempt to prepare for what might have been said?
I'll allow that. Go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged?
Because you
offense?
don't wing it
Objection,
at
argumentative.
trial.
Overruled. I'll allow it.
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also want to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
He's not one of the lead detectives. He is the lead detective.
So you made reference to
It's his job
not being any
to
surprises.
interview any potential witness. This isn't hard.
Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by putting the name on the record and saying where you went.
I will allow one more question on this. Go ahead. You may answer.
Could you ask a question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
It's almost like when you go to trial, you want all the information. You don't
Do you
present
recall
all
making
the
an attempt
information,
to interview the child
but you want all of it.
Objection, relevance.
who was 7 at the time?
Sustained. Next question, please.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
It's
Sustained
not
next question, please.
relevant.
Grounds for the sustain again?
It's
Relevant.
not relevant
How's it not relevant?
Keep going, sir.
because the
Did you interview the
child,
child?
Same objection.
Grounds.
Sustained.
they're
Grounds
not
for sustain.
witnesses. They didn't bring
Why would you ask to
other
interview the
than
child?
identifying him.
Objection. This
Sustained.
entire line of count questioning is inappropriate.
Sustained. Move on.
I would object that trying to interview a 7-year-old child is
Sir, move on, please.
He didn't say he tried to
It's also not
interview a
relevant.
7-year-old child.
Very
That's not
relevant.
an evidence.
it was a tricky move.
Stop with the commentary.
You made reference to in regards to exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, you're not.
But if his investigation leads to another
So
county,
how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer. Oh, with the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal,
I'm sorry for interrupting. I started off by saying in regards to exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
during the normal course of an investigation, we do background
you
on
go
a person to see if they have any
where the
cases
evidence is.
or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
In reference to having charges in one county and potentially being charged in another county in reference to that. Wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
I've heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant,
Grounds.
beyond the scope of the witness's knowledge. Legal conclusion.
Sustained for all those reasons.
Exactly. I mean,
So when did you become the lead investigator? in
you
this-
haven't
in
been
this
tried.
That was
For
about
bail
8:30 p.m. on
jumping.
November 21st, 2021.
That's
So
a
same night.
separate crime
Correct.
than whatever you were on probation
And
for, whatever you were
Who
on
were you
bail
made
for.
lead investigator by?
It's not double jeopardy.
Command staff or Lieutenant Jerry Habanic.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person, had the most experience to take care of it.
I mean,
That's what I've been told.
he traveled to Iowa.
Any other reasons besides that?
Also, because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in. So I already had a little bit of a head start with information that I already had learned as being there at the beginning.
And that would be the information that you said you had more knowledge of than anyone else at that time. Would that be
He still does,
in
I'm
reference
sure.
to having an interaction with the vehicle at some point?
I would say as a totality of the situation, I was there when the car first went through. I know what the radio traffic was. We're taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the
He
case.
was there for
I
the
was also on scene
aftermath.
downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
You referenced you were there at the beginning when the vehicle first entered in the
He
parade.
tried to
What do you
stop
recall
you.
about when the vehicle first entered the parade?
I remember a horn beeping, red for escape, driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean, a
The
horn.
vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
At
What would be
that
the only time a
point,
vehicle would beep their horn?
Objection, speculation.
Grounds.
Sustained. Calls for
Reason-
speculation.
Do you know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
you
Uh,
asked him
I've been
if
driving
he
a long
knew
time.
why.
And a lot of times people get angry, they're late, they beat their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
That's argumentative.
I assume that he was.
So it'd be fair to say you don't know for sure.
I do not know for sure, but that
Argumentative.
is my opinion, is that he was angry.
And at that time,
You can
you had
testify
no
whether
knowledge who
you
the
were
driver was. Would that
angry.
be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know who
time.
the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him?
Well,
Talked to
you
him?
have to
Talked-
be
Compound question,
specific.
ask
You have
one.
to be
I was just giving
specific.
clarification of no.
You
What I
need
mean
to,
by
it's a
no.
compound question. Please rephrase.
Before you observed this vehicle, as you say, this driver that, as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds.
Sustained is to the form of the question.
How would you know how someone's feeling if you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds.
I object. Improper question.
Grounds.
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time. And a lot of times when people are beeping their horns, it's because they're late. They're angry at something happened. And that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Objection,
Grounds.
irrelevant, speculation.
Grounds.
I'll allow it Based upon his training and experience, he may answer.
It's a possibility.
And did you hear this beep beep before the vehicle approached you?
Yes, I did.
This does not excuse you from murdering 6 people. You cretin.
You made reference to, and I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to. let me
He's
clarify.
been trying
Because I
that the whole
wasn't
trial.
clear. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony
All right, we're caught up in real time.
of and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that?
Come on.
Well, let me back up just a little bit. How were you able to obtain that ring footage?
From your mother.
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks's mother, was working. They spoke to her, and she's the one that alerted to them that she had ring video at the house
Exactly.
and offered to
It's their fault if they don't
download that
move.
video for them.
And were you there yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't
The
recall
very first time.
Let
I
him
don't recall
answer.
the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained. Hearsay.
The August 8th date that you referred to, was that in any way follow-up?
Follow up to
Follow-up
what?
investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation.
This is such a
The
stupid line of
investigation
questioning.
continues every day. It's not end. It will not end until this trial is over.
So what follow-up was needed at the time of the August 8th interview? I'm guessing that's what you would call it. I don't know. I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Miss Woods multiple times?
To get more information.
Because every time we spoke to her, we got different information. And at that time, we were following up with your niece and nephew of what their testimony would be in this case.
I assume they're on his witness list.
What testimony are you referring to? Because I don't recall any nieces or nephews testifying.
On August 8th, they didn't know
I think this
for sure who
line
would
of
testify
questioning
yet.
is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
He's gonna get mad. How dare she tell me what to do? Ain't nobody telling me what to do. Were his words yesterday. You can ask me what to do. You can't
Made
tell
reference
me.
to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
So this would be the discussion of proximate causation versus
To your knowledge,
actual
were any of those
causation.
charged?
So
My
he's
testimony
the
before is that
proximate
those
cause
people
of them being
cases were not
trampled,
charged.
but the trampling is the cause of their injury, not the Ford escape. Thus,
And were they seen
they
as
weren't
victims?
charged.
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
I'll sustain
I think so.
the objection as to the form of the question, if you could please rephrase.
His directs are going to be so bad. And get ready for days of objection leading from both sides. Because he's going to do nothing but lead his witnesses, and the prosecution will properly
I'm gonna go
object.
a different route.
But then he'll object to leading on their cross and then explode when those objections are not sustained. We've already seen the sneak preview with Juan Marquez. He's getting close. This is sovereign citizen time again. These big breaks are transitions.
Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
Drives me
It's for
nuts.
Mr. Brooks's jail cell.
For the record and for the jury.
And why did you serve a warrant for a jail cell?
To search it.
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
So there's a
What
pre-trial
was the warrant
ruling.
pursuant to?
I sustain the objection. Next topic, please.
He did answer.
He can
I
answer it.
sustained the
It was
state's objection.
sustained.
I'm directing him not to answer. We'll take it up separately. I'll have you
He's
continue
mad.
with your cross-examine. I'll take it up later.
Yeah, keep shaking your head, Nimrod.
You made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Back into it. Sovereign citizen.
Do
Mumbo
you yourself
jumbo.
know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
He asked you to be more specific, not ask the exact same question.
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
That you murdered 6 people and injured dozens of
I would
others.
imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. I would imagine that they would file a claim with their insurance company.
See, I would have
to
answered
have
this.
those bills
The state
paid.
filed a claim against you,
So
claiming that you
acknowledge that
killed 6
what
people
was
and
filed to
injured
their
dozens of others.
particular insurance companies.
I have no knowledge, but my assumption is that they would have filed those bills.
So it'd be fair to say you don't know for sure.
That was my testimony.
Honestly,
Is that the answer?
Yes.
he's such a tool.
As lead investigator for this matter, where are you, to your knowledge, aware of any
Plaintiff.
GoFundMe type of things? in
Objection
relation to-
relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
It's almost
And
like
what do you mean by
the
typical? You've
damage
seen
you
this before?
caused
Is that what
was
you mean by
expensive
typical?
and people
We
needed
have a
their
very
bills covered.
loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Because they knew they weren't getting a penny from
Is
you.
it fair to say that there's a lot of communities like that across Wisconsin?
Yes, I think there are.
And those communities probably contributed to the GoFundMes as well. Because you caused a lot of damage, both to human bodies and financially.
It would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it.
No, he wants
Extremely.
you. It's your question.
I'll answer yes if that helps.
I mean, it's your question. You define it. Ask a vague question. Specify if.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table in
Yes.
the trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude.
He doesn't
There
need
would
to be
a
excluded
court
because he
officer.
knows what
So
all
yes,
the
that's a very
testimony will
typical thing
be.
that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained is to the form of the question.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular
or-
case.
Exactly, Darlene.
I'm
And
sorry, you
it's a
interrupted.
foreign
me. Can you repeat
concept
that,
to
please?
him.
I believe he
Um,
said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation that sits with the prosecution in
Yeah.
reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
Grounds.
Sustained,
He's a court security
wanna know his
officer.
relevance.
sustained. Next
Reason
question,
for the
please.
sustain.
Because it's
Not
irrelevant.
He's been in the courtroom the whole trial. How's it not relevant?
Has he been a witness?
Mr. Brooks, next question, please.
Nobody knows who he is.
They do.
That should be known.
They do know who he is.
Nobody
But
should
it's
know.
irrelevant.
Relevant to
He's
the
not
issues
a
that the jury
witness.
needs to determine. Next question, sir.
Action, we're telling.
Because ain't nobody tell me what to do.
I'm assuming that's asking.
He's getting mad.
You know what the other one would entail.
Shut up.
Do you have a question, sir?
Yeah, I do. I would like to get to it.
And stop with the commentary
Please
and
do
ask
so.
a
Thank
question.
I will.
It'll be awfully unfortunate for him to get kicked out for his opening statement.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
Shut him down.
It's an entity.
How can an entity file a claim?
Objection,
him
down.
legal conclusion.
Grounds.
Sustained.
Jackson Brown
You are
says the
aware that
captions.
only a living, breathing human being can actually file a
No,
claim.
that's
A-
not the
a
law.
Entity cannot
That
walk
is not
into
the
anywhere
law.
and file a claim if it's not even a real person.
Objection,
You
move
are
to
aware of
strike.
that, right?
Go ahead, Attorney Apper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end
I
as
mean,
irrelevant,
Apple can
argumentative,
sue
calling
Google.
for a legal.
Those are entities
Objection
suing
is not
other
calling for a
entities.
legal conclusion in any
The
way.
court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated also is a misstatement of the law.
No, I definitely object to that, Your Honor.
It is
Your
a
objection's
misstatement
noted.
of the law.
I'm going to have the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I'll take exception to that ruling
You can take exception to it all you want.
and would like a legal
was-
finding of fact.
It was the appropriate ruling.
Objections noted, it's overruled.
And that's a judicial determination.
Stop arguing.
I think you be seated.
This is the prosecution strategy.
Go ahead, Mr. Brooks, please continue with your questioning.
Make him furious before his opening by issuing proper objections.
Have you ever had any interactions with this entity, state of Wisconsin?
Shut him down. 90611.
Mr. Brooks, under 90611,
Thank
I'm
you,
not going to allow
Judge.
the witness to answer. It's vague.
There was no objection.
Under
The judge
90611,
under
I shall
90611.
exercise reasonable
can-
control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
gonna keep coming up.
And I
And she
determined at that
has
time that
told
they
you
weren't
to
relevant. So
stop.
next topic,
They're gonna
please.
keep coming up.
She told you to stop.
Under
If they're
90611,
going
sir,
to keep
please
coming
move on
up,
to a new
she can
topic.
end your
They're gonna
cross.
keep coming up.
For
Then
the
the cross is over.
cross-examination, I will end.
Do you see the state of Wisconsin president
Okay,
in the
end it,
courtroom
end it,
today?
Judge.
Objection, argumentative,
Grounds.
irrelevant.
End it.
Sustained. Final warning, sir. Next topic or the cross-examination, I will.
You
Bring
don't
it to an end.
gotta keep doing that, Your Honor. You don't gotta keep doing that.
It's my
Well, you keep
responsibility,
bringing
sir,
these questions.
over this trial.
She
I'm
has to
informed,
keep.
and I
Thank
res-
you.
And I
Next
respect
topic.
that,
No, you don't. You don't know what
but it's
respect
relevant for the
is.
jury to know the truth.
Shut up.
They deserve to know the truth.
Stop.
Move to strike, Your
arguing.
Honor.
Granted, the jury will disregard
Regret.
those last statements. They're
Objection
not
to that.
relevant.
End it.
Mr. Brooks is not testifying. They mistake the
90611,
law.
Judge. End it.
I object to that. That's not
End
lawful
it.
law. It's
Noted.
not truthful.
All right, under 90611, I
Thank you,
am
Judge.
now stopping the cross-examination. Any redirect by the state?
Objection to that. And I would like
Noted.
legal finding of fact.
She doesn't have to
Do
give
we
you
offer
one.
any redirect?
Yes, just very briefly, Your Honor, I would like to display for the
Oof.
witness only
Squirrel-
exhibit
One squirrel's facing the
178.
other across the lawn.
Objection.
I haven't seen the exhibit yet, so I'll take
Well,
that under
I'm
advisement.
objecting still because
You may show it to the witness.
there needs to be an answer to why the jury's not being told
Shut
information that
up.
they deserve to know.
Go ahead, Attorney Hopper.
Your Honor, for the record, this is a video I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me
I mean,
see it and I'll
when
take
did
your
it become an
objection under,
exhibit?
I'll
It
take
was
the
never
objection under
exhibit before.
advisement.
Stop
Go ahead.
I haven't
arguing.
seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Stop.
Go ahead,
I
I
Attorney
have all the
Hopper.
exhibits.
Go ahead, Attorney Hopper. I haven't seen it yet. There's nothing on my screen that I can see. I see it's now playing.
So now we just creating exhibits now. I have all the exhibits.
Stop
This was
with
never
the
in-
commentary.
Oh man.
All right, you can stop.
The middle
Sir, do you
prosecutors
recognize
finding a
what's
smile
contained in
at his
State's Exhibit
ridiculous
178?
behavior.
Objection.
Overruled,
Relevancy.
overruled. Go ahead
Leading.
and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness may answer.
I'm still gonna object. How's this? I
Mr.
have
Brooks, I
all-
ask that
Stop
you
I
honor
have all
arguing.
the
the,
ruling that
I
I've
have
been
all the
made.
exhibits though, Your Honor. I have them
Mr.
all.
Brooks,
They were provided to me and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out
up
of the blue?
outside the presence of the jury, but I'm gonna allow
Can
it.
that be stated for the record? Can that be
Stop.
explained?
No, the jury
arguing.
will disregard the statements made by Mr. Brooks. They're not evidence. And the statement
So this
continue.
exhibit shouldn't be evidence then because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted, it's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing
mine,
in front of the
Bob.
Ford Escape.
Stop
This is the
arguing.
video in which that still photo was taken from.
You could-
Objection.
It's
How does
being
he know
brought
that?
in under the
Um,
rule of completeness.
Overruled. The witness may
You
answer. I'll give you the opportunity
You-
to question him about it
brought up the
when the state's done
validity
asking
of
the
the still
questions. Go ahead.
photo that was shown because your back was turned.
Where'd you get this video
So
from,
this
sir?
is the rule of
Objection,
completeness, bringing
Overrule
in
the
the
witness may
whole
answer.
video.
From Mr. Brooks' social media account.
You made it
Your Honor,
an
move
issue,
to
so
admit
they brought it
178
in.
and permission to publish.
Objection to the relevancy.
It's relevant
I
because
find
Still
it's
doesn't know how
relevant.
this
I'll
obtained.
receive
You
exhibit
question the
168. Permission
authenticity
to publish is
of the
granted.
still.
For the record.
It's
Could you please-
178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds. We're going to play it in its entirety, but without volume, Your Honor.
All right, thank you.
And,
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without
Your
audio.
Honor, I have all the exhibits. They were provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to
But
address.
how can you play something that's not, that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
It's
Mind-boggling.
mind-boggling because you
Actually,
don't
Your Honor, I
understand the
change my mind. I
rules.
would like to play the audio, please.
This is mind-boggling.
Shut
I want to have it played
up.
first without, and then I'll make a ruling and I'll take that up.
Okay, I understand.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played?
I'm assuming this is one of
He's just
his
setting the foundation.
YouTube
It's
rap
relevant. You questioned
videos.
the officer about it. You
I
questioned this
question him
detective
about,
about
I
his
question him
knowledge.
about the still frame from the video.
And this is the
The
entire
wasn't
video
even in
to
the
validate
exhibits that I
this.
received.
Still, it's the rule of completeness.
I actually didn't even receive them.
Mr.
They were
Brooks, please
obtained.
stop. The jury will disregard his statements. He's not testifying. The video's playing.
And all wannabe rappers, remember, the Bentleys, the Lamborghinis, they don't matter. You've got to do your rap videos with a 2010 Ford Escape.
So play the sound. I want to hear it now.
Shut up.
I'll address that later.
The sound's irrelevant.
We address why it was created out of the Bluetooth.
Shut up. You questioned the authenticity of the still that was taken from the video. It had your back. It was used to show the escape with the license plate. That was the frame where the license plate was the most clear. You questioned the detective. Well, how do you know it was me? This video is how they know it was you. You made it an issue, so they brought it in. Yes.
Go ahead, attorney, after the video's finished playing.
Inhuman
Thank
waste.
you, sir. Did you see during the playing of that video, the image that was captured as a screenshot and presented to you in your direct testimony as states exhibit number 175?
Objection leading.
Overruled foundational, the witness may answer.
Yes, I
A lot of.
Shut up.
You were questioned on cross-examination as to your ability to identify Mr. Brooks in exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as states exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection. I don't consent to being called that name. And yeah,
Noted. Do you have any
Question.
questions for the witness?
This when did this video? When was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That
Sustained.
was a question. A question. When
Sustained
was this
as to the
video
form
made
of the
exhibit?
question.
When
The
was
witness
this video
did not
made
make this
an
an
exhibit?
exhibit.
That is a question.
Not
I
for
object
this.
to the question
witness.
directed at the witness, Your Honor. It's beyond the scope of his knowledge.
He
Sustained.
Well, he
did
said he
not
saw
make it an
But that's not the
exhibit.
question asked. So you
The
can rephrase your
prosecutors
question. if you
made
wanna-
When did
an
you see this
exhibit.
exhibit? When did you see it?
With the understanding that you're asking, when did he see the video? I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I
That it would be the same thing. I'll take that as disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please?
and faces.
Admonish him
Yes,
because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, I'm good. Can I?
You're
can I
the
go?
one acting like a clown.
State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
ever see nothing.
She's not looking at
I'm
cameras.
advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint,
Shut up.
to
I'm
be
with-
respectful of this jury's time and attention,
be
and
it.
to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday and again this morning, and now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday
furious.
and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
He's so mad.
Overruled, the witness may answer.
He's so mad.
Because I wanted to be 100% sure of the content, and if there's any
He knew he
questions
was
that were asked of it, I wanted to
testifying
make sure that
about
I
a
would
still
be able to
from the video.
answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained
It was
as to the
not
form
brought
of
up
the
in
question
earlier
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked or however you refer to it?
How
What
dare
would
the
be
witness
need
show
to
up prepared to testify?
view again this morning something that you had viewed numerous times before?
I'll stay with my
Objection,
Hold on.
objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
Did you view the video this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts, not in evidence.
Sustained as to the form of the question.
He didn't know that you were going to basically open the door to the prosecution playing the video. They didn't plan to play it until
Can you clarify
You
again why you
questioned about
viewed
it.
the video this morning?
Objection, asked and answered.
Sustained.
morning,
So you're gonna
Teresa.
sustain everything?
It was already
He,
answered. sir.
he's
Next question.
steaming.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
Oh,
Thank
he's
you.
so
This is
mad.
mind-boggling.
Detective, you may step down. I'll excuse the jury.
What you people was trying to do is not fair.
Shut
Hide
up.
things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I ask that you honor my decision to do that and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked. That's the only reason, because you asked.
No, she didn't ask. She's telling you
I
to
see what you
behave.
people are trying to do. It's not right.
She is the judge.
It's not fair
This
and it's
is
not
her
right.
courtroom.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Opper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr. Brooks, I need to
something that
make
I
a
saw.
record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would-
inaccurate, Your Honor.
It
Can
wasn't
can
made
have
an
the prior
exhibit,
counsel
but it was
testify to that?
provided
Not
in
at this time,
discovery.
I have not obtained that.
You haven't
Right now, that was
looked
my
at it.
first time seeing that as an exhibit.
Mr.
That's why I
Brooks, I
raised the issue.
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons. The first of which, it goes to identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through
Exactly.
his knowledge of it and the identification by him of you in it because the still image was of your back.
Okay.
So that opened up the door, and it's proper.
Exactly.
There's absolutely no surprise to you that that video exists. And that is my finding as it
What do you
relates to
mean
that.
by it's
And
no
to
surprise to me
quote
that it exists? That was not the issue.
again,
The issue was how was it made an
boom.
exhibit at the last moment? How does it be made an exhibit out of the blue?
She just explained it.
That was the
You
issue.
opened the
issue
door.
They can make an
had
offer of
anything to
proof
do
on
with
that
it.
because
An
obviously
exhibit.
they marked it as an exhibit.
But
They
with
had
all
it.
respect,
So go
Your
ahead,
Honor, you're
Attorney Opper.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was how does this, at the last minute, out of the blue, become an exhibit?
Attorney
That
Opper,
was the
go ahead
issue.
and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection,
aware.
he said social
There's
media. He
nothing
didn't say what it was.
Sir, stop interrupting. We have to make a record of it. You've
Then make the record clear.
interrupted multiple
Stop
times. I've been
interrupting.
abundantly
Make
patient
the record clear.
with you. Again, another
Maddening.
interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at
Are
me.
you?
Stop
I'm looking
mumbling.
right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be
She's
quiet?
instructing you to shut up.
Go ahead, Attorney Opper.
Thank you, Your Honor.
gonna take that
And
as
just
action.
to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are.
Exactly.
And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that We came up with the video, which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial.
Ooh.
Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors
Or the
of being
witnesses.
unethical and hiding things.
Or the blue
There is
suited
nothing
ESO.
in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible.
Not Brooks.
Not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here.
She's got steam
So
coming
I
from her
apologize
ears.
for my tone with the court.
Oh.
I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is
They've
no
gone over
exception.
and above. I love Sue
I apologize
Opper.
for my tone, Judge.
I
Thank you.
love
I
Sue
appreciate that
Opper. She is
additional-
amazing.
Record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that
Probably talks
video.
about
But my decision
violence
to admit the video without audio stands.
or sexual
I do want to take up two other
misconduct.
issues. There was an objection to questions regarding cross-examination. So the
She's
objection
not
by the
broken.
state,
She's
one had to do with possible,
passionate.
there's questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction? I believe it was with your mom and possible testimony of your niece and nephew.
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
She has bit her tongue.
What information do you want to provide to me
Oh.
about that last exhibit?
She's bitten her
About
tongue.
what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't
There
know
was a reference made
specifically
to-
what you're
There's
talking
a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an
She's been
exhibit.
laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I
for her to sit there-
haven't made any of those observations,
I didn't
sir.
say
What
you.
I've
I didn't
observed.
say you, Your Honor.
No.
But
What I've
for
observed
her,
is
for her, listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Nobody
That is
said
very
sir.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't
Her
know what you're
laughing under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole time. I didn't
need
say
specific
anything. I didn't say
instances, sir,
anything
because
about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary
Idiot is too
issues or
kind.
about testimony.
So why is it always laughing and giggling?
I
involved
haven't
with that?
noticed that other than the one thing you pointed out.
Well, we
today,
have
which that-
cameras.
She's
That's
not
what the
watching
cameras
the
are for.
cameras.
Let's refocus our attention on what we're here for, and that's
Okay,
this trial.
then I take
And
that
do
as
you have anything you
take
want to
that
put on
as-
the record?
I'm putting it on the record if I
As
get a
it no,
chance.
you need to let me finish. As it relates to the video and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not that she just said she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you.
one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of any.
need legal basis for when she just admitted on the record that she just made this exhibit up
No,
right
she
now?
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying
the
that by saying
exhibit.
that she can
She did
pull
not make it
anything
up.
out of her suitcase.
I mean, she hasn't
So that's a
been
figure of
During-
speech.
Okay, so what is it
Right.
implying to? What would that be implying to?
As
direct
How would
attorney,
anyone-
comment
how would
I'm
anyone
moving
in my
on
position-
because you're not
How
providing me
would-
with any
how would
legal
any-
basis
I didn't even
for
finish.
me
You
to.
told me that I can make the record. I'm attempting to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything-
that. You didn't even let me
You're
finish.
not letting me
You
finish.
didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you know I
you're
wasn't getting to
providing
that if I
commentary.
didn't finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal
There
basis.
should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes,
That's ridiculous.
you're representing yourself.
At
It's
some
not
point.
ridiculous.
It is ridiculous.
Be
So I was supposed to already come in here this morning to say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find
You're
some legal
supposed
thing
to know the
combat.
rules.
How am I
Mr.
supposed
Brooks,
to do that?
you open, the bottom line is you opened the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during
We're not
discovery.
talking
There's
about opening no doors. We're
absolutely
talking about
no,
being fair.
there's
Because
absolutely
if I
no
would've did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
With
by
all
that
due
exhibit.
respect, if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking
you
me?
need. I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down and
I don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be
Exactly.
present
So
in
you're
this
holding me in
trial.
contempt
It's preparation.
Mr.
for the entire trial. Did you say the entire trial?
I never said any such
You said
thing.
for the trial. So what do
Please?
you mean? I'm asking. What do you
Mr.
mean?
Brooks, you continue to
That is
come at
not.
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give
you
you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it
asking
relates
me
to
to
other
do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you. Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if
Got
appropriate,
prison
Mr.
bingo.
Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks
The gavel
about
on
possible testimony and why it had to do with it was in the
Huh.
context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August. And there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics is my first question.
Okay, why was it an issue with me bringing up the
Mr. Brooks,
jail
I'm
search?
only gonna ask you one more time, and if you
I'm
don't
saying,
answer
if I don't
correctly,
understand,
then I
if I
will
don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
Mr. Brooks, listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I
a
don't like
yes or
I don't
no.
like your tone and the way you're talking to me. I don't. I don't
Brooks,
appreciate
He
it.
doesn't like her
Sit down.
tone.
I don't care if you
Nah,
don't like my
I'm not
tone.
gonna-
You've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too.
the utmost of respect
No,
for
you
you,
haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's
Stop
not accurate.
talking.
What you mean stop talking?
I need to make a ruling. Okay,
Well,
I'm purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's talk to each
now.
other like adults then.
Mr.
Because
Brooks,
I've never told you to stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answered
cell?
my question. We'll move on.
I'm
not
trying
gonna give
to
him that
understand.
opportunity.
If I
All right,
don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Thank you,
what I'm
everyone.
supposed to answer if I don't understand? And I don't agree to a stop.
Oof. Oof. He he's awful. He is absolutely awful. And with that, I'm going to take my very short break with that mic drop. I'll be back in a second. All right, I'm back. Static. Your pigs don't need that toxic filth in their life. You need to feed the pigs a good diet. And I realize you run a rescue farm. Your pigs are not food. But I imagine the bacon that would come from pigs that were fed Darrell Brooks would not be good bacon. He's just toxic all around. I mean, I've mentioned my brother has a dozen, 15, 20 chickens, and he's got 2 turkeys and the corgi. So the chickens get fed table scraps. I mean, they're fed chicken feed too, but they get a lot of chicken scraps. And if I walk out of the house carrying a plate, they follow me back to the chicken run area because they're pretty free range. They wander the whole yard, but then they've got a smaller penned chicken run, and then they've got a enclosed, like with a roof and chicken wire, hen house plus completely fenced in area, which is necessary because otherwise the hawks get them at night, or we've had bobcats on the roof of the hen house, coyotes in the neighborhood. We live close enough to the mountain that we do get wildlife down in our neighborhood. So yeah, we feed the chickens anything and it disappears right away. I wouldn't feed the chickens, Darrell Brooks. Exactly. I'm not an idiot. Assumes facts, not an evidence. Although I think that would be a mischaracterizes the previous testimony. And this opening, the judge gave him a sheet right at the beginning with the rules and expectations of his opening, including that he's not to bring up subject matter jurisdiction in it. And he was offended. I knew that. This trial would indicate otherwise. But he can't argue in his opening. He's been told that. He said he doesn't plan to argue. It's to lay out the facts of your case and give a roadmap. I don't think he understands what argumentation is. This is going to be all argument. It's going to be misstatements of the law. It's generally considered bad form to object during an opening statement. It's going to be Objection City. So the opening statement is given before presenting your case in chief. So for the defense, the start of trial is before their case in chief, but after the prosecution rests is also before their case in chief. So you can reserve the right to give an opening statement after the prosecution rests. So the fact of the matter is, at the beginning of trial, you don't even know if you need to give an opening, because it could be that the prosecution leaves out elements of their case, of the actual charges. Like, if somehow, I don't know how it would have happened here, but if somehow they had not brought up that this was done in the state of Wisconsin, I'd stand up and I'd say, Your Honor, I move for the case to be dismissed. After they rest their case, I move for the case to be dismissed for lack of jurisdiction, because the prosecution has not proven that this happened in the state of Wisconsin. Or in the case of the one charge with the dancing granny Lola Hospital, until the detective testified on this morning, bringing up that Lola was injured, I didn't think that there was any evidence that she had been injured, because the one dancing granny had testified that she wasn't injured. So I would stand up and testify, Your Honor, I move for dismissal because it hasn't been proven, and I specifically move that this charge be dismissed because the only testimony related to Lola Hospital was that she was not injured, thus the elements are not satisfied. So, or, Your Honor, I move for dismissal of the charges. No one has identified Darrell Brooks no one has positively ID'd my client. Which isn't the case here, but just as an example. Or, Your Honor, he's charged with dangerous weapons enhancements. There has been no evidence of a dangerous weapon, except they did bring that in yesterday, specifically by making the SUV an actual exhibit, showing it to the jury in person, bringing testimony of how it was damaged. So it would be a due process violation to not give him the opportunity to give an opening. But if he misbehaves during it, she can say, all right, this is your warning. Continued misbehavior will end your opening. So she still has to walk a pretty fine line. But I mean, he can waive his opening, so misbehavior could be construed as him waiving it or being finished with it, or so. I have no idea how long he's going to last. The judge asked him either yesterday or the day before how long he expects his opening to be. He said, I don't know. How am I supposed to know how long it'll be? Well, you're supposed to have an idea of what you're going to talk about in your opening. Ideally, you'd have written it down, practiced it, even memorized it. Or even if you don't have it memorized, you have a PowerPoint or, something to talk through, a visual. But as long as he's not breaking the rules, meaning argumentative or stating the law as he sees it, she'll give him leeway as to time, as long as he's not rambling, as long as it's not cumulative. So as long as he's moving forward, she's not going to shut him down. And so that's it. It could be 5 minutes. It could be 3 hours. My guess is it's closer to 5 minutes than 3 hours, but an hour and 20 minutes is closer to 5 minutes than 3 hours. So I'm expecting it to be slightly shorter than the prosecution's was. I didn't time the prosecutions, so I couldn't tell you exactly. It's definitely going to be improv. It's definitely improv. He hasn't shown preparation throughout the trial. He's prepared, as in he's found his ex-lawyer's questions, and he's prepared his sovereign citizen script of questions. He may have even looked over the exhibits that he thinks a witness is going to testify about, because he's shown some familiarity with the exhibits at the very least. But when the judge has instructed him to read up on the rule of hearsay, he's refused. I don't think he's read up on 906.11, which is the judicial control of the examination and witnesses and stuff. I don't think he's, she instructed him to read up on permissible leading. She gave him the citation, at the very least, where it is in the code, during Juan Marquez out of order testimony. He didn't bother to even glance at it, even in real time. So, I mean, it's 11:45 now in Wisconsin. So I'm wondering if he gets to it, or if they come back, do a little more argumentation, and then go to lunch. Get started after lunch. Give him a chance to cool down. But that is because you're not a complete moron like Darrell Brooks. I mean, pauses are fine. He pauses thinking through. I do too. It's not a knock on him. It can make it difficult to follow, but I mean, like I've said, I think Prosecutor Wishnow, is that his name? The young man who did the opening, he's an absolute rock star. That's one of the best I've ever seen. I've mentioned multiple times
The record in State versus
The
Brooks
Trevor
appearances are as
Summers
they were
trial that
before.
Law Talk with Mike covered, and how people criticized the younger
Let's do that.
prosecutor
All right, let me do that again.
on her
We're
closing
back on
argument,
the record.
because there were a lot of
State
ums
versus
and
Brooks
pauses, and
appearances
she
are as they
wasn't
were
quite as
before.
dynamic.
I don't consent to being called that name.
But that was an above average job. I thought she was very good.
Are there any
So let's see what happens here.
issues related to exhibits or other things before I bring the jury back out for what I believe will be the state resting?
No, Your Honor, I do believe that I did check with your clerk. Everything that we have offered and admitted matches what the court has. So I believe we are good on that.
I have one question about Exhibit 89. and I don't know if I missed in my notes,
Okay.
what do the parties' notes reflect on whether that was received?
I showed that it was offered and admitted before it's published, or it wasn't published to the jury. But if not, we would move Exhibit 89 into evidence.
And do you recall what exhibit 89 is?
It's a
Otherwise-
certified bail form.
No, I'm asking,
Oh.
I'm asking Mr. Brooks.
Oh,
So,
sorry.
that was the second of the 2 bail bonds. Do you have a recollection of whether it was received?
I don't.
Right, and
I
then what
know I
was,
objected to it.
I know you objected when it was, I think, displayed for the witness who then testified about it. I'll receive it and also advise the jury. Were there any other exhibits? I have one other issue on evidence and exhibits as well, but are there going to be any other exhibits that we need to tidy up the record in front of the jury with?
I don't believe so. I know at one point, someone caught that we moved, it was either exhibit 175 or 178 into evidence, and the court admitted either 165 or 168 on the record. So I don't know.
So maybe just
I
had a
think you
misspeak.
Yeah.
You have any recollection of that, sir?
Recollection of what?
Related to what the state just put on the record. Do you know what, was that, what witness that was?
That was Detective Kate.
Look at that. $175 was the screenshot taken from the video. I know I have a note that it was received and published. And you believe I may have just referenced it by the wrong name?
I thought it was 178. I thought you referenced it by the wrong number. So it's either 175. 175 was referenced as 165, or 178 was referenced as 168.
What is 170? I know that 175 is what I just said.
Correct.
What was 178?
178 was the video.
Oh, that was the
video.
most recent one. Okay. What's the request then as it relates to when the jury comes back in?
Your Honor, I just, there's 2 different ways to do this. I can put on the record, I have the exhibit numbers, and I can just put on the record just to verify that these exhibits have all been offered and admitted into evidence, and the courts
They
agreeing, because we just
could,
agreed that those are.
it's more difficult
Your records
than
are the same as my
law and
records.
order would have you
Or we
believe.
can clarify
because,
just if there was some confusion
You know,
about exhibits
stenographers are
175 and
typing
178
with
that were shown
their
to the jury this morning. those
abbreviated
175 and
keyboard, and they
178
have
offered,
to
and
go
the
back
court
and
had to
translate
admit
it
those. So however you
basically,
want to.
and it's just a lot of
Sir,
work.
do you have any position on
It's easier
how
to just
I address
discuss
this
it
in front
now
of the jury?
and make sure it's on the record and received.
Yeah, I'm objected to him being admitted at all.
Well, those objections were already addressed. I'm talking about how I addressed to make sure the jury knows they were received by the court.
However you gonna do it is how you gonna do it. I don't think what I gotta say much matters.
Well, what you say matters, sir, but
No, it
the
don't.
fact that I've already ruled on the
Definitely.
admissibility is not something I'm gonna revisit.
Exactly.
What I-
No
what I gotta
control on
say-
it.
Hold on, that door is, all right, it's, sometimes that door upstairs malfunctions and, all right, I didn't hear the last part of what you said.
What I have to say about anything definitely doesn't matter.
I take huge objection with that, sir.
It's true.
And that may be your perception, but that is absolutely not true. this court takes your positions on evidence, legal arguments, admissibility, things of that nature. I take all of that quite seriously.
But somehow it's always overruled or discarded.
So can I keep
It's
going because you
because
interrupted me once
she
again?
rules based on
My
the law.
perspective on all of this, sir, is when you disagree with a ruling, you interrupt. You try to debate the topic again and again. You make disparaging remarks either directly or under your breath that are audible.
And
Sometimes you roll your eyes.
Always.
I mean, just previous to the break, you and I were talking over each other. I couldn't really get a word in edgewise. You wanted to debate
They can't
topics
get
that I've
anything
already
from the stenographer there.
made decisions on. I wanted to get clarification on whether you wanted to pursue any questioning, for example, with Detective Casey. I gave you multiple opportunities to answer questions directly. You chose not to do that. You directly challenged me about my authority in this courtroom. You refused to sit down repeatedly. Did I raise my voice? I absolutely did. Was I frustrated? I absolutely was. I'm sitting down. My voice is calm. I think the break was good. I hope for all it was good for me. We had had a very long morning. It was about 11:30 when we broke. It's now 11:54. I didn't remove you to the other courtroom despite my repeated warnings because frankly I knew I was going to take a break. I just wanted to get through some issues outside the presence of the jury, which is the proper procedure for how to address objections if the record can't be done in a way that when a more full record needs to be made is how I'll put it. And I indicated during the cross-examination of Detective Casey, I would take your objections under advisement. I would address them outside the presence of the jury. You chose not to answer my questions. And so I moved on.
Yeah. Stare at the ceiling.
Now, with
Determinedly
respect to,
not looking at
I
the
want to
judge
also
because
address
he's mad.
exhibits and the normal course of exhibits coming in a trial. Because I think there's some
explaining the law to him
misunderstanding and certainly confusion on
because
your part, sir, about
he doesn't
the
know the
exhibit
rules.
list that I asked the state to file near the beginning. And that was frankly
It's
to
not
assist
controlling.
the court and my clerk in keeping track. Most trials, the normal course of action is as long as an exhibit has been provided to a party previously, or in some circumstances, if not, it's rebuttal. We're not quite there yet. That as long as it's been turned over in discovery, oftentimes parties will simply have exhibits marked as they're presented in the course of a trial. There's not a legal requirement unless a judge orders it that would prohibit a party from marking a document that's been already exchanged and having it offered as an exhibit.
Either way, it's childish.
There was nothing improper about what the state did with exhibit
Traffic
178.
court doesn't have stenographers.
And I want to make that record very, very clear.
For murder trials, I
As
think
Attorney Opper stated,
they're going to have
trials are fluid.
one way or another.
Things happen. Parties can open the door to what might be inadmissible evidence for a variety of reasons. For example, this court made a number of pretrial rulings related to other acts evidence. Even during your cross-examination today, you came awfully close. I had the witness turn to me and pause and say, I don't think I can answer that, in a clear recognition that that witness, Detective Casey, understood his obligation to honor the pretrial rulings. And we moved on from there. I bet that's happened a half a dozen times in this trial. And that's frankly
at least
to protect your rights, sir.
And yet you still don't understand why they stopped you from
The door
asking
could
those
have been
questions.
opened a long time ago to the other acts evidence with Erica Patterson. And I frankly kept it out.
I bet he opens the door when he
despite your questions.
questions her on direct examination.
So with that, I want to bring the jury back out. I will ask the state. I'll simply just ask the state, are there any anything additional the state's offering by way of testimony or exhibits? You can then address the exhibit issue. Then I'll ask the state if the state has any additional witnesses, and the state can officially rest. Given the time of day that it is, it's 11:58. I'm not going to have Mr. Brooks start with his opening statement. We'll do that when we come back after the lunch hour. I think, frankly, the time over the lunch hour will be good for everyone to regroup, hopefully get a little bit to eat, and come back fresh. And then we'll have his opening statement and the start of testimony. Before I bring the jury out, there's one other thing I want to do, though. I just need a moment to pull something up from on my computer.
So is that addressing subject matter jurisdiction that you're pulling up?
No.
When would that be proven for the
Sir,
record?
please don't interrupt me. I
He's
need
done
to
with
focus
that.
on what I'm
I'm not
doing.
interrupting you. I'm just asking a question.
I'm not going to be addressing that. So
So would it be
don't
proven
interrupt
on
me
the-
right now. I'm trying to do something on my
Would it
computer.
be
I need to
proven on the
focus.
record?
I feel it's important at this time to at least give you the advisement pursuant to Special Material 28. It is regarding your decision on whether to testify. I'm not asking you to make that decision, but since we're on the verge of you starting your case and it may impact your opening statement, I wanted to go through the following. Sir, are you aware that you have a constitutional right to testify?
I've been informed.
Are you advised and informed that you also have a constitutional right not to testify?
I'm not advised, I'm informed.
Are you advised and informed that the decision whether
Who
to testify
advised
is
and
for you to
informed?
make?
I don't understand the question.
Are you advised and informed that the decision on whether you testify in this trial is for you and you alone to make?
I'm informed. Not advised.
Are you advised and informed, sir, that if you choose not to testify, the jury will be advised that they cannot use that against you? In other words, you have that right not to testify.
I'm informed.
When you make a determination about whether to testify in this trial, I will further be asking you about whether anyone has made any threats or promises to you to influence your decision. I may also briefly go over your educational background. Did you hear me say that?
No, I'll say it again.
At the appropriate time, when we go through this discussion more fully, I will also ask you whether anyone has made any promises to you to influence your decision on whether to testify. Did you hear me say that?
I'm informed.
And then I will also ask you if anyone's made any threats or coerced you in any way in your decision to testify or not,
What's the significance of that?
so that I can make appropriate findings about the voluntariness, intelligence, and your, whether it's knowing, voluntary, and intelligent, your decision to testify.
So whether I give consent.
That's not the legal determination that I make. It is simply something that is your choice. I will honor your right not to testify. Obviously, that's a constitutional right. I will honor your right to testify. That's also a constitutional right. And the jury will be advised one way or the other. There's a jury instruction on that. Did you hear me advise you of all of this?
I'm informed.
All right. Okay, let's bring the jury out then, and we can kind of tidy up the record, and then we'll break for lunch.
Judge, may I remove that exhibit, please?
I think they're right there, so let me just take it.
All right, it's heavy.
Jury already coming out.
Yeah, he said
So
bring out the
don't
jury.
worry, sit it back down. Thank you. Subject matter jurisdiction still hasn't been proven for the record, Your Honor.
The jury's on its way out, so it's time to argue.
Should be
Subject
proven
matter
at some
jurisdiction.
point.
Remind me not to do that twice. Remind me not to do that twice. That hurt. Thank you, everyone. Please be seated. All right, then I'll turn to the state. Any additional evidence at this time?
The state
State
rests.
has no additional evidence, Your Honor. May we make a record as to the exhibits?
Go ahead, please.
Your Honor, we believe that the court has admitted all exhibits that have been offered, with the exception of one prior ruling on Exhibit 6. I don't know if you want me to list them all by number, or it's 1 through 78, 1 through 178, but there are some numbers missing because we chose not to offer those exhibits.
Anything specific as it relates to the most
Because once
recent
again,
testimony?
they're not
Most
required.
recent testimony.
Use all the exhibits
with,
they prepare and
Detective
number.
Casey, we moved
They get to
177
decide
and 178
how to
and
present their case within the
One-
rules.
I'm sorry, 175, 150, 151, 88, and 89. I believe those were admitted by the court.
That's my recollection as well, but for the jury, exhibits 150, let me start over, exhibits 88, 89, 150, 151, 177, and 178.
That's
If I
exactly
didn't
what
receive
he's
them
doing, Si.
during the testimony, I'm receiving them now.
And 175, which was the still photo,
Thank you, sorry, I had to scribble on my pad, and 175.
and 13 and 14. Those are
Okay.
the outliers, I apologize.
I believe those were received as well, but if I didn't
Objection, I
state
think
it,
they was already received.
I appreciate that. I just want to be thorough for the record. So 13 and 14 were received as well. Do they have any additional witnesses to call at this time?
No, Your Honor, at this time, the state rests.
All right,
Woohoo!
thank you. All right, then at this time, we are going to break for the lunch hour. I am going to have everyone come back at 1:30. It's a little bit longer, at least that's what I want to do for the lunch hour.
You need
today.
to
So
do
I'll rest
the-
for the jury.
Opening statement on a full stomach. Oof. All right. Any argumentation from him before they go to recess? Because this is the jury walking out. So I wonder if we get argumentation before recess.
Thank you. Be seated. Mr. Brooks, anything from you at this time, given the state is now rested?
This would
What
be
you mean?
I'm asking you the question. Do you have any requests at this time now that the
As
state is
in-
rested?
would you like
Request
to
for-
bring a
pertaining
motion
to what exactly?
to dismiss
I'll
the
ask the
case?
question one more time. Do you have any requests to make at this time now that the state has
She
rested?
can't give you hints.
I don't understand what what
She
you
can't
mean
give
by
you
that. That's why I'm
hints.
trying to get clarification.
I'm not going to give you legal advice. I'm simply asking the
This is
question.
where you
Do you have any
bring a
requests to make at
motion
this time
to
now that the state has
dismiss.
rested?
As I've explained, it would be
I
malpractice
don't know what I'm
for
supposed
me
to say to that.
if at this point I didn't say,
don't
Your
understand.
Honor, the state has not
What-
proven the case. I move to
Would that
dismiss
be pertaining to?
as a matter
I
of
can't
law.
give you
don't
legal
know.
advice, sir. I'm just
There's-
asking the question to make a record. I'll ask you one more time. Do you have any requests to make now that the state has rested?
He's so
I
confused.
don't understand.
He
All right, the other thing I want to do when the jury
Oh.
comes back out is, you will
And
recall I
if he
read
doesn't
instruction
bring the
101
motion,
at the
it's
very end of the preliminary jury instructions that just has to do with opening statements. I will read that with the caveat, it will just say that the defendant will now make his opening statement. The purpose of an opening statement is to give the parties an opportunity
mean,
to tell you what they expect the evidence will show you, so that you will better
But he
understand the
has to do
evidence
it
as it is introduced during the trial. I must caution you, however, that the opening statement is not evidence. So I'll read that. I think it's appropriate given the.
like I said, it would be
Mr.
malpractice
Burford,
for me
his
not to
opening
bring the
statement
motion
until
right
the start
now.
of his case.
But
With that, we will take our lunch break. It's 12:09. If you could be back here at 1:25 and be ready to
That's
go
true.
at 1:30 with your opening
I
statement.
got a question.
Go ahead.
Do I get to present exhibits and stuff like that too and admit them into evidence?
Say, at what point are we talking about? Do you want to use exhibits that have been received during your opening? Is that what you're asking me?
No, I'm saying if I got my own stuff that I want to offer into evidence, which is a question I
I
asked
mean,
previously.
you
Do you
can,
believe the state has all of those
and
documents
that
they
is
might be able to
pretty
assist with?
standard
Are they
after the
new
jury brings its
I don't know what you
verdict.
mean by new documents.
You can,
Are they
and
documents
the
from the discovery
JNOB
that you
he
have?
mentioned
They
is the
documents
judgment as a
of
matter
my
of
filings
law.
and stuff like that. I'm sure they have copies of everything
But-
that I filed.
I guess without knowing specifically what you're referring to, sir, I did
Lawyers
give you the
have to bring
admonition
one now as
previously
well.
that you are
You can bring one
prohibited
at the
from
end, but you have to
discussing
bring
subject
one
matter
now.
jurisdiction during your opening statement. It's not relevant.
I'm not referring to the opening statement. I'm referring to things that
I
I
mean,
want to
it's
offer
super
Give me
rare
an
for a
example,
judge to
please.
grant it, yes.
I just did. I said I have filings that I want to offer into evidence.
That's too general, sir. I need a specific example so I can answer the question. What are you referring to?
And,
My
and
filings,
that's it.
everything
Which
that I filed,
filing, sir?
every one of
When
them.
it's
They
abbreviated,
have to be
if
relevant,
it-
number one, to the
even if it's
proceedings. Okay, number
stated as a judgment as a
two,
matter of
I
law,
don't know specifically what you're
still
referring to. You
shorthand.
can't offer
It's generally
testimony
just
of yours
JNOB.
through an exhibit. That would be hearsay. So you'll have to testify if it's your statement that you're referring to.
I'm not referring to I didn't say anything about testimony. I said
I'm being
filings.
general based on what I've seen thus far. So, are you talking about during your
He
opening
doesn't know how
statement or
to
during
do
the
it.
course of the
He
questioning
hasn't
of the
read the
witnesses that you're
rules.
calling?
Your Honor, with all respect, I just clearly said filings that I filed.
Mr. Brooks, if I understood, I'd answer. I don't understand what you're asking me. You need to be specific.
I filed a number of documents. I think
And
That's
those
on the
aren't
record.
Without knowing
evidence.
what you're referring to, then my answer is no.
Those
But
aren't
Again,
evidence.
well, I guess I'll have to wait and see as to when you seek to
Like
admit
if
them
you're talking
whether there's
about
any
motions
objection or
you've
not,
submitted to
and
the
whether
court,
they're,
those
whether
aren't
they
ev-
comply with
it's
both
not
the rules
evidence.
of evidence and the rules of procedure. That's the best I can tell you at this point.
I don't understand what you mean by that. They will only be relevant to obviously the matter.
He wants to get a sovereign
They
citizen
won't
Sir,
be
I-
relevant to anything
I
else.
can't answer that
He
anymore.
wants
We're
to
gonna take
bring
our
his
lunch break.
motion
12:12. We'll see everyone back here at
for-
1:25. We are in
about
recess.
subject matter jurisdiction. He
So I'm
thinks
not
that's
allowed to
evidence
offer
bring
anything
up.
in evidence.
For the record, I never said that. We are in recess.
So I'm trying to understand.
He's trying to understand, but she can't explain it to him. She's not his lawyer. Ugh. Okay. I'm going to go eat my lunch now because I want to get here before court starts again. I don't want to be late this afternoon, so I'm going to end it here. I will see you guys all back for the 3-ring circus. The the Dipshit Brothers Barnum and Bailey circus. Back in about an hour. Thanks for joining me.